Oftentimes the EEOC will be a great source of amicable resolution to an existing claim at the early stages of the litigation, and this benefits both sides, the employee and the employer, in the sense that quick resolution is always the goal, to the extent that you don't have to drag through a 3-year proceeding where it can be disruptive, of course, to your life, your livelihood, and also very stressful for both the employee and the employer, and certainly costs have to be considered. The EEOC, in my experience, is very effective at getting the parties to mediate. Lately, especially in the past year or so, the EEOC has mediated more cases with my firm, which have resulted in very positive outcomes for the clients, on both the employee side and the employer side. With respect to employees, the desire to mediate oftentimes is questioned, and the issue always is, of course, what is my case worth? That's a very case-specific, fact pattern focused analysis. And the issue of what your case is worth is always dependent on a lot of factors, including what you were earning, what type of damages you suffered, whether you found subsequent employment if you were in fact terminated, whether you suffered any kind of medical related illness or treatment that you had to undergo as a result of, say, a termination. And of course, going forward, we always have to look at any future losses. The question always becomes, how far into the future you can go also in collecting damages. In my experience, the EEOC mediators are very experienced in mediating cases, and they do have special skills that are enabling to an amicable resolution in terms of bringing the parties together in a way that can foster a positive outcome, certainly at the early stages. So I would always recommend for the employee to, yes, absolutely, go to mediation with the EEOC if that's an option that's offered to you. It's an excellent resource that you should certainly exercise as soon as possible once it's obtained.